Good morning. Nice to see you all this morning. Mr. Crawford, you're going to be first, and I notice you're muted, so you might want to address that first. And my question to you, sir, is you going to reserve 5 minutes?
Yes, Your Honor, if I may, please.
Okay, we're ready whenever you are.
May it please the court. Good morning. My name is Andrew Crawford. I'm here on behalf of the appellant, Ms. Dana Bunce. This is an appeal from a final judgment for protection against stalking from Pasco County. Your Honors, there is 4 issues in this appeal. I'd respectfully want to speak about the first issue as it relates to this particular case. The record revealed that Ms. Bunce did not know the appellee in this case, and the appellee received a series of anonymous text messages, letters, as well as some Facebook postings. The issue is whether or not these were sufficiently tied to Ms. Bunce. Based on the case law.
Mr. Crawford, just a question. That's a very interesting issue, and you've briefed it well, and I'm anxious to hear more about it. But my question is, this injunction was entered a year ago on
Correct.
September the 3rd, right?
It was.
Isn't it done now?
No, no, it's not, because in fact, she's moved to.
Well, I don't want to hear facts outside the record.
Understood.
But I just couldn't help when I read this case. I saw it was entered a year ago. A year has passed. But you're telling me it's not done. That's really all I need to know, because anything else you would tell me is outside of my record, and I don't want to know that. Okay.
Correct, Your Honor.
So go ahead, stay with your argument about this evidence and the failure to connect.
In this particular case, the trial court observed a series of text messages, as well as screenshots of telephone calls from multiple different area codes.
I'm sorry, I'm going to interrupt you again.
Yes, ma'am.
We've read the transcript, and the trial judge listened, I think, fairly patiently over a couple of hours to a series of introductions of evidence and colloquy and testimony. And the standard of review here for us is abuse of discretion. So you're asking us to disagree with the trial judge on what she found was sufficient.
Exactly
Am I
right.
wrong?
No, you're exactly correct. You're exactly correct.
A lot of the cases that address these types of issues focus on the nature of the of what the communications were, what the text messages were, what the voicemails were, and all that, and whether or not they reveal enough personal information that they can be connected to the person who's suspected to be the sender. I mean, as I read through this, I felt there was a lot of personal information in here that would have allowed a connection to your client. So help me understand why you think otherwise.
Well, Your Honor, again, these were a series of text messages and telephone calls. The telephone calls do not relate whatsoever to Ms. Bunce's telephone number, as she testified to. Same thing with the text messages. The text messages themselves.
Well, that wouldn't be the first time some clever person, disguised it by using some other number. Right.
True, but there's still a prerequisite for admission of those phone calls or consideration of those phone calls to tie it to the appellant.
Well, the trial judge heard some testimony around that during the hearing, and the possibility that this could have been robocalls. And again, going back to what Judge Morris said, there was a lot of information, and just looking at the exhibits with the text messages, they didn't come from a random telemarketer. So I'm sorry to be redundant, but the trial judge was in the best situation at this hearing to assess the credibility of these parties and their claims. And when I asked you a minute ago, you said what you're asking us to do is essentially reweigh that evidence and conclude that no reasonable trial judge would have done what this one did. I have a hard time with that on this record, and so I'm asking you to tell me where I'm missing something.
Certainly.
And Mr. Crawford, I just want to jump in on the tail end of that question and just ask you, what is the burden of proof in an injunction hearing?
Well, Your Honor, the burden of proof, it varies with each injunction because, of course, there are certain things that needed to be proven. But generally speaking, it's the greater weight of the evidence. But with stalking, based on the nature, the statutory definition of stalking, there's a number of other elements that need to be shown in this particular case.
Okay, but it's by a preponderance, isn't it?
The greater weight
Greater weight of
evidence.
the evidence would be by a
Correct.
preponderance. Okay.
Correct.
And be sure and address Judge LeBrit's question. I didn't mean to, this is part of that question in my mind.
Certainly, Judge LeBrit. Well, I understand that the burden or the standard of review here is abuse of discretion. There's also an evidentiary burden here that the petitioner in this injunction obviously had as the statute, and to tie into the abuse of discretion, if it's a question of evidence, it's reviewed de novo, trial court's interpretation of the evidence. So I would add that. In this particular case, I understand that there is some testimony here, but in terms of the telephone calls themselves, there's not a single number here associated with the appellant in this particular case. In terms of,
excuse me, I'm sorry. I think that you're going to have to focus on something other than the root phone number here, because we all know how that works, and the trial judge understood that herself. And I understand that you weren't present at this hearing and that your client made the choice to represent herself pro se.
correct.
But here's the way I see the record. Ms. Harper came in, she had her petition with the exhibits. She explained a series of facts to the judge that were designed to meet her burden under the statute, ranging from the text messages, the telephone calls, the social media postings, the cat kidnapping, and everything in between and to the end of all that. And I'm sorry to be redundant, but I have a lot of heartburn with trying to second guess how this trial judge shook out. As the trial judge said, it's a circumstantial case and she thought it was a close case. But at the end of it, having heard all of the evidence from Ms. Harper and from your client, who testified and discussed with the trial judge extensively why she thought, including in the form of her objections and the colloquy that was had on those, why she thought Ms. Harper hadn't carried her burden. But at the end of it, the trial judge concluded that she had. And she was the one looking at these people in the face and listening to their stories. And so I'm apologize to keep you tied to this one issue and this standard, but it's the one that we have to live with here.
It is, and obviously I know that this court can't reweigh the credibility of witnesses. That's not what I'm asking. What I'm specifically talking about is based on the case law that I've cited within the initial brief, as well as the reply brief, specifically the Walker versus Harley Anderson case, which is from the 4th District Court of Appeal, that's similar to that case. There was not sufficient evidence to admit these anonymous letters, calls, text messages, and other things that the trial court considered in order to make the determination that the petitioner in this particular case met her burden of proof to establish stalking. There's no fingerprints on any of these letters. There is no, as the case is cited within the Walker case, this was not obviously taken off Ms. Bunce's cell phone. Furthermore, it's our argument, as it is on appeal, that this type of evidence, similar to the evidence in the Walker case, was insufficient to authenticate these anonymous calls and letters to the petitioner.
Well, I'm going to interrupt you again, because the way I see the case, looking at the record that we have, is Harper goes in and says, here's what happened to me. This is how I know it was her. These are things that only she reasonably could have known. And provides documentary evidence of that, and admittedly different phone numbers and these text messages, and your client's defense for all practical purposes was, it wasn't me, I didn't do it. And the trial judge resolved that against your client, and your client didn't herself introduce any evidence other than her own testimony to the effect that I didn't do it. So,
which the trial court found to be the most damning evidence against her.
That was the trial court's finding. Correct, Your Honor. I'm sorry. Continue, Ms. Judge LeBrit.
No, I'm sorry. I'll try to leave you alone.
I understand. I think that we're talking about. I understand how the court ruled, but as a predicate to the admission of evidence, the court obviously has to make a finding based on what's presented to her or him, that these are from Ms. Bunce. The argument on appeal is that was not sufficiently linked up. Now, the petitioner in this case said that she had a confidential address, confidential voter registration, confidential, a number of things based on her ex-husband being in law enforcement pursuant to the public records law. However, all of this information was posted online in her online divorce filing. It was a public record. So to say that it was something that only Ms. Bunce could have known is just not accurate as it relates to those pieces of information. Furthermore, again, none of this was found on Ms. Bunce's cell phone. None of this was mentioned her name specifically. None of this information came directly from her, or nor was it proven that it was from her. Before that can be considered by the trial court, there has to be sufficient authentication. As Professor Earhart has said, just because someone says they sent the email or text message is insufficient. There has to be more here. And while Judge Morris, you're correct that certain times there is certain type of evidence that can be considered by the trial court, individualized characteristics and things of that nature. The cases cited within the Walker and Harley Anderson case show a litany of examples of that. For example, in the Simonette case, that was involving a criminal case, a robbery case. In that particular case, the Fourth District Court of Appeal found that the texts were sufficiently authenticated because, number one, they were found on the defendant's cell phone, and number two, the co-defendant specifically testified that she was texting the defendant while this robbery was occurring. We don't have that here. The next one, which would be, State versus Love, which is a Fifth District Court of Appeal case. So that was specifically a letter. That would be information only known to the perpetrators, crime details, the co-defendant's relationship, incriminating evidence, and plan to fabricate testimony. Again, we don't have that here.
Let me ask you, sir, that I share your concern about that, about the sufficiency of the evidence, but I've highlighted 13 portions of testimony that go to the ID. Now, I know that Ms. Harper testifying that I believed it was Bunce because of the history of this wouldn't be enough. Or Baer told me that Bunce had done the same thing in the past may not be enough. But we go on and on of 13 instances whereby the witnesses testified to the effect that the conduct that Ms. Harper was testifying to in order to get this particular injunction was very similar, if not identical, to conduct in the past. And I know your client preserved some of those objections and there were rulings, but assuming that the witnesses can testify, because I know texts are hard to authenticate unless you admit it, email, same thing. But I'm getting to my point. I'm sorry I'm taking so much time, but if a witness can testify, I got that same text from her. It said the same thing in the past, and she's doing the same thing to this particular person. That seems to be what's going on. Is that insufficient if you have repeated instances of testimony about that, about different aspects that seem to be identical?
Judge Sleet, in answer to your question, there was a number. The petitioner in this case testified that she had spoken with Mr. Baer's ex-wife, who had something similar to this happen to her in the past. That person obviously was not there to testify. That was obviously based on complete hearsay.
Well, Mr. Baer testified, though, and
he did
corroborated a fair amount of what Ms. Harper was alleging.
Well,
and the similarity issue that Judge Sleet just identified.
Mr. Baer testified specifically at the hearing that this type of text messaging as well as letters was very similar to stuff that he'd seen in the past. I believe Judge Sleet's question was related to the previous two individuals who did not testify at the hearing. But you are correct, Judge LaBritte, that Mr. Baer did testify to that. However, there was no further details other than that it sounded very similar.
Well, I mean, you recognize, of course, that if there's any evidence in the record that would support the trial judge's conclusion and ruling on this injunction, we are probably bound to affirm. And the fact that not only Mr. Bear, but Ms. Harper testified, and I get that there were objections and whatnot, but you get two witnesses who say this happened and it happened the same way with similar cadence. I think Bear talked about cadence and sort of vocabulary usage. I'm still struggling with, it was circumstantial and it was a close case, but did this trial judge do something that no other trial judge on this record would have done?
And Mr. Crawford, just so you know, you're into your rebuttal time now. Okay, it's your time, but I just want you to know it. Okay.
If it's okay with the court, I'd respectfully reserve the balance of my time.
Okay, that's fine. All right. So, Ms. Westbury, I think your job here is to show us why you think this evidence is connected to Ms. Bunce. Okay, I'm just trying to focus what you're about to tell us because that's obviously what we need to know. Okay.
Of course. Yes, Your Honor. And may it please the court, my name is Lisa Westbury, and I am the attorney for appellee Amanda Harper. In relation to the sufficiency of the evidence that does tie this to the appellant, I would argue that the case law indicates there must be a prima facie showing to authenticate the evidence, and that can be done by the appearance, the contents, the substance, internal patterns, all taken in conjunction with the circumstances. I would argue that here, Mr. Bear testified it was the same content and substance he had seen with his ex-girlfriend, his ex-wife. And that was what Ms. Harper received in this case. She received text messages, phone calls, letters. All of these communications referenced Mr. Bear. So the only connection can be Ms. Bunce, the appellant. Due to the reference to Mr. Bear, it's obvious, and it can be distinguished from the Walker case on the basis of the fact in the Walker case, the court notated that there were 10 pages of messages submitted. 5 of them were different from the first 5. And there were also references to the wrong gender, we versus I. So that's not the same as here. In our case, we do have sufficient evidence because Ms. Harper testified that she received these messages. She provided the messages. All of them contained the reference to Mr. Bear. And then we have Mr. Bear testifying that, yes, these are the same content and substance of the messages that my ex-girlfriend and wife have received. And then we get to the court and we have the appellant saying, no, I didn't do this. And that was it. It was her testimony. And the trial court noted she would have been better off had she not testified and found, yes, it was circumstantial, but everything together was enough to prove that it was Ms. Bunce who sent these messages. Or maybe not prove, but more likely than not, with the greater weight of the evidence.
It's hard to read into the transcript just on the basis of the cold record, but the content of some of Ms. Bunch's objections and testimony, and she seemed to disparage Ms. Harper and make some negative comments about her. To me, that would support the trial judge's conclusion along the lines that you just outlined, and I'm trying to frame that up so that your opponent can address that specifically in his rebuttal. Is that essentially your point?
Yes, I think credibility was a huge factor in the trial court's decision in granting this injunction. And that was the basis of me not even asking her any questions on cross-examination. Was everything was just out there. And so to streamline it and have the judge decide based on what she had heard in that evidence alone, I submitted it to the court and asked her to weigh the credibility of the parties based on everything that she had seen, the testimony that had been elicited, and the evidence submitted.
Well, there's no direct evidence that Ms. Bunce sent this.
No, it was all
So help me
circumstantial.
out.
It was all circumstantial, Your Honor. It was all the messages that were submitted in support of the petition, the text messages, the website postings of the different cheater sites.
Did the court take judicial notice of the prior injunctions that were filed, because there were repeated references to those?
Your Honor, I can't say if the court did take judicial notice. There was nothing on the record that they did. There was some mention of prior injunctions during the testimony of the hearing, but I can't say for a fact if the court did take judicial notice. I do know there was lengthy discussion in regards to the injunction that appellant had filed against appellee in Hernando County on the basis of the email address that was created, but I don't know to the extent that the court took judicial notice. And I
Okay.
would go
Yeah,
ahead.
I'm going to ask you to look, I think we can all look at this in the record at page 32. There were 4 different items that the trial judge took judicial notice of, having to do with prior cases involving Ms. Bunce and these parties. I hate to do this to you in the middle of your argument, but we want to hear your position on that. And one of the things that Judge Hand wrote this in was that she had judicially noticed injunctions between the parties in Hillsborough and Hernando and Pasco, as well as related family cases and related criminal cases involving respondent.
Yes, Your Honor, and thank you for pointing that out. It does look like the court did take judicial notice of all the different cases involved in relation to the parties. And if you would like, I can speak as to what happened to them. I know there's some mention in the record, but the big thing was appellee was trying to get protection. She had filed in Hillsborough County. She dismissed it when all the acts of stalking had stopped. And then when everything restarted, she contacted the Pasco Sheriff's Office, the Pasco State Attorney's Office, and filed her petition for injunction in Pasco County, which happened to be the same day that an injunction was filed against her in Hernando County. So there was quite a bit of history between the two. So the statement that appellant was not sure who appellee was, I have a hard time believing that, just on the basis of all the information contained within the injunctions, as well as the notice of filing of exhibits and the motion to dismiss by the appellant. So our argument is that she knew very well who appellee was, and she is the one who committed these acts, and the evidence, though circumstantial, is enough and is sufficient to tie her as the one who committed these acts. And if there are no other questions, just focusing on the sufficiency of the evidence, I would ask that you affirm and keep this protection in place for Ms. Harper.
Thank you. Mr. Crawford, you have 5 minutes, is that right? Yep, 5 minutes. Go ahead.
Thank you, Judge Morris. Judge LaBritte, when I ended my argument, you had a question. I want to make sure I answered it for you at the initial part. I believe you answered a question, and then Judge Morris mentioned that I had 5 minutes left. I wanted to make sure I got to your question. I believe it was regarding the sufficiency of the evidence as it relates to the weighing of credibility. In this particular case, the petitioner had the burden of proof to specifically not only prove that these text messages were from Ms. Bunce, but that she established the statutory definition of stalking. As the court noted, it was a very weak circumstantial case. However, she did ultimately decide with the petitioner in this particular case. I respectfully submit not only were those text messages and other contacts with the petitioner insufficiently tied to Ms. Bunce, I'd also respectfully submit that there was insufficient evidence of stalking. It's a reasonable person standard. It's supposed to be strictly construed according to the case law. And I respectfully submit that in this particular case, these messages, telephone calls, and Facebook postings were not sufficiently tied to Ms. Bunce. Based on the record before us, as well as the case law that I've cited in particular in my initial brief and my reply brief, I'm going to ask this court to reverse and remand for dismissal of this injunction.
Okay. Thank you both. This is, these injunction cases are tough, and when there's circumstantial evidence like this, they're even tougher. But you both did a great job with these issues. So thank you very much. Have a nice day. This concludes our docket. We'll spend the rest of the day trying to sort these cases out and figure out what to do with them. And I appreciate your help in this one. All righty. Have a
Thank
good
you.
day, everyone.